Okay, if you're ready, I'm going to start letting people in.
Okay, I'm ready. I just had to turn off something. I'll tell people that there's no live stream. Okay.
Okay, yeah, everyone is connected, so you're telling them.
Can we start?
Go for it.
Okay. Good afternoon. This is the beginning of the workshop in case number 20-00175-UT concerning potential amendments to the Commission's PURPA rule, which is 17.9.570 NMAC. My name is Judith Amer. I'm an Associate General Counsel at the New Mexico Public Regulation Commission. And I would like to welcome everyone here today.
Sorry, everyone. It looks like we lost Judy there. I'm sure she'll be back in just a moment. So while we're waiting for Judy, we had originally planned on live streaming this meeting so people could watch it. For some reason, there's an issue with the YouTube account, and we're not able to actively start the live stream right now. So we're going to do an audio recording of the workshop here, and then we're going to post a link to it on the website. So anyone who isn't participating but wants to see what happened will be able to watch a recording of the workshop. We apologize for the live stream not working. I did a test yesterday and it was working fine, but something seems to have changed with the YouTube settings since then.
Hello, my internet seems to be a little unstable today. I'm sorry. I don't know if anybody heard what I was saying, but where did I drop off?
You probably started, you're talking, just saying it's a workshop regarding the PURPA rule, and then you started glitching out a little bit there.
Okay, and my plan here is just to give a very brief overview of what the new PURPA rule allows states to do, and then go around to the list of participants and ask each one, what they're interested in, what they foresee the next steps should or would be for the commission to do. So at that, I will, for those of you who are extremely familiar with the new FERC rule, this might be a little repetitive, but I am going to read from FERC's fact sheet dated July 16th, 2020. It's entitled Final Rule, Qualifying Facility Rates and Requirements, FERC Actions Regarding RM 19-15-000, AD 16-16-000. And what it states is, and I quote, this final rule revises the Commission's, meaning FERC's, regulations implementing PURPA to better align those regulations with the modern energy landscape, while continuing to encourage development of qualifying facilities, QFs. Regarding rates, bullet point number 1 grants states the flexibility to require that energy rates, but not capacity rates, in QF power sales contracts and other legally enforceable obligations may vary in accordance with changes in the purchasing utility's avoided costs at the time the energy is delivered. Bullet point number 2, grant states additional flexibility to allow QFs to retain their rights to fixed energy contracts and to allow such rates to be based on projected energy prices during the term of a QF's contract. Grant states the flexibility to set as available QF energy rates for 1, QF selling to electric utilities located in organized wholesale power markets at the locational marginal price, which is they refer to as LMP in those markets, subject to a rebuttable presumption that the LMP represents the as available avoided cost of utilities located in those markets. Or 2, for QF selling in electric utilities to electric utilities outside of the organized wholesale power markets at competitive prices from liquid market hubs or calculated from a formula based on natural gas price indices and heat rates. And the final bullet point in rates is to allow states to set energy and capacity rates based on competitive solicitations, such as RFPs, conducted pursuant to transparent and non-discriminatory procedures consistent with the Commission's Allegheny standard described in the final rule. So those are the changes regarding rates. There's also the change regarding the 1 mile rule. Bullet point number 1, it modifies the 1 mile rule for determining whether generation facilities are considered to be at the same site for purposes of determining whether it is a qualifying small power production facility. 1, there will continue to be an irrebuttable presumption that facilities 1 mile apart or less constitute a single facility. 2, parties can show that the facilities are located more than 1 mile apart but less than 10 miles apart constitute a single facility. And 3, there will be an irrebuttable presumption that facilities 10 miles apart or more are separate facilities. Okay, that's it for the changes of the 1 mile rule. Now on to the obligation to purchase. Bullet point number 1, revise the regulations that provide for termination of a utility's obligation to purchase from a QF with non-discriminatory access to certain markets. Number 1, there's a rebuttable presumption that QFs with a net capacity at or below 20 megawatts do not have non-discriminatory access to those markets. But that has been changed and it has been reduced to 5 megawatts from 20 megawatts for small power production facilities, but it remains unchanged for cogeneration facilities. Okay, that was it for the changes for the obligation of purchase. Legally enforceable obligation. It requires states to establish objective and reasonable criteria to determine a QF's commercial viability and financial commitment to construction before a QF is entitled to a contract or legally enforceable obligation. And the last change is regarding self-certification. First, allows an entity to protest a QF self-certification or self-certification without having to file and pay for a declaratory order. 2, protests may be made to new certifications, both self-certifications and applications for commission certification, but to only self-recertifications and applications for commission recertifications that make substantive changes to the existing certification. And that's a very brief summary of the changes that the new FERC rule makes. And the Commission's current rule does need to be amended to include those changes. And so that being said, I would go around and now ask all attendees to just state their name, who they represent, and if they have anything they would like to add in terms of what they're interested in the new rule amendments containing. And I will start off with our PRC staff, John Reynolds and Brad Borman. I don't know if Brad is available. If he's not, then just John Reynolds. John, I think you're still muted, or are you unmuted?
Yeah, this is John Reynolds. I'm unmuted.
Okay. And as I said, if you don't have anything to add, then you can just say that. If you have anything to add, this would be your time.
Not at this time. I mean, I'd like to hear from the utilities about this. I mean, it's at this point still a significant learning experience from staff perspective.
Okay, and Brad Borman also, or is Brad not here?
I'm here. You know, I'm probably going to defer to John on most of these things because he was, you know, more involved, I think, in preparing our comments than I was. You know, I'll just leave it at that. I'll step back and let John have the spotlight.
Okay. All right. Well, we can come back to you. The second organization is El Paso Electric. There were several people from El Paso Electric signed up. I don't know if you all would like to speak or if you have designated one person to speak for your organization.
Hello, this is Omar Gallegos, Director of Resource Planning at El Paso Electric.
And Omar, are you speaking for the entire El Paso Electric contingency?
We have also with us Nancy Burns and Ron Moss, who will be also participating.
Okay. Do all three of you want to speak?
Yes, at times all three of us will be speaking depending on the topic at hand.
Okay. Well, then go ahead, Omar, then we'll go to Nancy and Ron, okay?
Okay. Yeah, and at this time, I don't have any additional comments to add. I'm the
Okay.
Director of Resource Planning at El Paso.
All right. And then Nancy, do you have anything to add? It looks like you're muted. Can Nancy Burns be unmuted?
Does not look like Nancy is muted.
Okay.
Good
No one-
afternoon. Good afternoon, Ms. Amer. My name is Judy Parsons. I'm a regulatory case manager with El Paso Electric. Can you hear me?
Yes.
Great, great. Thank you. I apologize. I was speaking and I was on mute earlier when you asked for the participants. So the participants that we have on the line right now representing El Paso Electric are Jim Schiestel, and he's our Vice President of Regulatory Affairs. Curtis Hutchison, who's a Supervisor of Regulatory Case Management. Omar Gallegos, who was just speaking, and he's our Senior Director of Resource Planning and Management. Victor Martinez, who's a Manager of Resource Planning. Nancy Burns, who's our Deputy General Counsel, as well as Ron Moss, who will be representing us as well as counsel, and Trish Griego, who's a assistant. As far as any comments from EPE, our position, our next steps, for that, I'll defer to Nancy Burns, who's on the line, and any of the EPE team members who are representing the company to speak up.
So Judy, this is Ron Moss. I think Nancy's having a little trouble getting in.
Okay.
As you know, we filed comments a couple of weeks ago, whenever it was, and I think at this time we're just standing on those comments, and we're interested in hearing what other people have to say about those comments, and we're interested in discussing other proposals as well. So we plan to be an active part of this process and look forward to working with others on this.
Okay. Well, then we can circle back. At this point, I'll move on to PNM. We've got at least signed up Adam Alvarez, Stacy Goodwin, Ryan German, Leslie Padilla, Nicholas Phillips, and those were the people from PNM who signed up. Is there anyone from PNM who would like to speak either on behalf of PNM, everyone, or would you all like to speak? I see Stacy. Why don't you go first, Stacy?
All right, this is Stacy Goodwin on behalf of PNM. You can hear me?
Yes, I can hear you.
I think I'll just speak for everyone else, and Leslie send me a note saying otherwise, but PNM did file detailed comments. We had proposed some language amendments. We agree with the comments of the other utilities and with the Rural Electric Co-op Association with regard to the need for flexibility in addressing some of the provisions in Rule 570. We do think that the rule amendments are necessary given the FERC actions recently, and we're happy to participate in any further drafting or workshops on the issues. But I think our comments provide the detail that you might want from PNM.
All right, thank you, PNM. Next, we'll go to SPS XL. The sign-up sheet, we have Zoe Lees, Bill Grant, Will Dubois, Susan Breimer, and Mark Walker. I don't know if SPS XL has designated one person, but I see Zoe, and so why don't you go first, Zoe?
Hi, Judy. Thanks.
Hi.
Yep, all of us may be talking depending on what we're discussing here in the meeting. At this time, SPS rests on its comments that it filed and is looking forward to participating in this rulemaking.
Okay, next we move to the electric cooperatives. And is Bobby Ferris here?
Ma'am. Thank you, Ms. Judith.
Do you have anything to add at this time, Mr. Ferris?
Yes, ma'am, Ms. Hamer. Lee County, we filed comments as well, and we'll stand on those comments, but we do look forward to seeing the final purple rule when it is published and look forward to the opportunity to help with amendments to Rule 570 with the PRC.
Thank you. Next, Mr. Dave Spradlin from Springer Electric Cooperative.
Thank you very much. So Springer, our statewide association, the New Mexico Rural Electric Cooperative Association, filed comments on behalf of the co-ops, and we will stand behind those comments and look forward to further discussion.
Thank you. Mr. Matt Caves from Western Farmers Electric Cooperative.
Thank you. Yes, Western Farmers, we filed comments as well. We'll stand behind those comments. We do look forward to see how this progresses. We do want to make sure that any changes taking into account the Southwest Power Pool, which we are a member of, the RTO and the integrated market, because there's a lot of interplay there that we need to be mindful of.
Okay, thank you, Mr. Caves. Next, Mr. Jason Trujillo, Mora San Miguel Electric Cooperative.
Yes, thank you. As David from Springer noted, the New Mexico Rural Electric Association filed comments on our behalf, and I'm just interested to participate and discuss further today. Thank you.
There's also Mr. Les Montoya, but since Mr. Trujillo just spoke on behalf of Mora San Miguel, I will move to Mr. Vincent Martinez from Tri-State G&T.
Good afternoon. I have no comment.
Thank you. There was also Mr. Tim Woolley from Tri-State.
Good afternoon. This is Tim Woolley with Tri-State, and we did not file comments in this docket. We believe Tri-State is exempt from Rule 570, and we are actually dealing with that right now in some litigation. So we abstain from providing any comments to this rule. However, I'm just here because of the several members that Tri-State has that are part of this and participating. So I do want to stay plugged into this.
Thank you. Mr. Lance Atkins from Farmers Electric Cooperative. Mr. Lance Atkins, Farmers Electric.
Yes, can you hear me now?
Yes.
Great, great. I don't have anything to add beyond the comments filed by the New Mexico Rural Electric Cooperative Association, but certainly appreciate the opportunity to be able to listen in and participate. Thank you.
Okay, we've got a couple people from Socorro Electric, Adriana Ariano and Marilyn Madrid. Would either one of those people like to say anything? Adriana Ariano or Marilyn Madrid? I guess not. Mr. Chris Martinez from Columbus Electric Cooperative. Oh, it looked like Miss Ariano's mic is not working, but I'm not sure why. I got a message. Mr. Chris Martinez from Columbus Electric, are you able to speak?
Yes, can you hear me now?
Yeah,
I don't have anything to add. Thank you.
all right, thank you. Ms. Marianne Roman from Hamus Mountain Electric Cooperative?
Yes, good afternoon. I'm Mary Ann Roman, and I do not have anything to add at this time.
Thank you. Okay, Mr. Kevin Grunwald from New Mexico Rural Electric Cooperative Association?
Judy, can you hear me? This is Dan Najjar. Kevin's on another call right now, but he will be joining us shortly.
Okay,
And we have nothing more to add beyond our comments.
all right. Then we have certain companies. Soluna Solar, Mr. Jim Desjardins.
Hi, this is Jim Desjardins, and I don't have anything to add at this time.
Positive Energy Solar, Mr. I might mess up your name, I'm sorry in advance. Mr. Tayoko Sadawik. Positive Energy Solar. We can come back. Mr. Ron Flax Davidson from Pure New Energy USA. Mr. Flax Davidson? Okay. Mr. Rocky Ray from Pure New Energy USA.
Yes, this is Rocky Ray. I'm with PNE. We have no comments at this time.
Thank you. Ms. Carrie Bellamy from Geronimo Energy. Ms. Carrie Bellamy from Geronimo Energy. Hello.
Hi, my apologies. I had a hard time getting off mute. I don't have any comments at this point. Just look forward to participating in the discussion. Thank you.
Thank you. Mr. Jason Marks.
Good afternoon, Judy, and
Hello.
all my friends from all the cases we're litigating. I'm not representing any client in this at this time. I have clients who I think will be interested, and I'm going to report back to them. I have no substantive comments on the proposed rules, but I just based on your introduction, Judy, I am wondering whether some of these things are proper scope for an MPRC rule, in particular the 1 mile rule and self-certification seem like things that are wholly within FERC's jurisdiction and wouldn't have anything to do with anything the state might do in rulemaking.
Thank you for that. Thank you for that comment, Jason. Next, I have Mr. Michael Newell. Mr. Michael Newell. I'm not sure he's present. We've heard from Dan Najjar. Next, Anastasia Stevens.
Hi there, can you hear me?
Yes.
Oh, that's amazing. I did it right for once.
Yeah.
Anastasia Stevens from the City of Las Cruces, and I'm just here to learn because I looked at the FERC order and it's like 490 pages. I thought this would be more efficient. Thank you.
Thank you. And let me see if there's anyone else. Having trouble with this document. I think that's it. So we have several entities that have filed comments and would like to rest on those comments. I might circle back to John Reynolds to find out what you think is the next step in this process, John?
Based on my review of the comments that the parties provided, the participants provided, it seems like it may be time to go through the sections that parties are proposing to amend and try to synthesize those into amendments that would apply to the state generally. I mean, I've noticed that some of the amendments had to do with situations that only certain parties deal with, like the Western Energy Imbalance Market, or RTOs like SPS would only apply to certain parties and not statewide. I mean, that's the first, my initial reaction to the comments that I've seen.
Thank you. So are you suggesting leaving those the sections that only pertain to certain utilities? Are you suggesting leaving those unchanged, or just at least at the first step working on the statewide implications, and then on the second step the more utility specific ones? John?
At this stage, I haven't seen any comments that, or any suggested language that was, that had any concerns with, other than trying to incorporate multiple sets of proposed languages into an overall framework, an overall rule, so that it would apply to the utilities where it's applicable. So, for example, if there's a definition of the Western Energy Imbalance Market added to the rule, then the Southwest, a definition of the Southwest Power Pool should be added to the rule as well. Not one or the other, but both.
Okay. Well, as you know, the commission, the PRC, has been involved in litigation regarding legally enforceable obligations. And the new FERC rule states that the criteria for establishing a legally enforceable obligation are demonstration of a financial commitment and commercial viability. Does staff, would staff be able to propose more specific criteria to define what those words are?
I don't know that staff could do it on its own, but maybe in the context of a workshop with the participants, staff would be willing to try to draft something based on feedback from the participants.
Would any of the participants like to comment on that in particular?
Well, Judy, this is Ron Moss for El Paso. I mean, we have proposed some criteria. I believe that PNM also proposed some criteria. SPS proposed some criteria. It seems to me that we have some markers laid down out there for things that would constitute objective and reasonable criteria. So I think those probably could be put into a rule for parties' consideration and discussion. Maybe not all of them, but at least some of them. So I think we're part of the way there.
Anybody else like to comment on that?
This is Stacy Goodwin for PNM. I agree with Ron that we've laid out some pretty good parameters that really are based on what FERC has said, and I do think that there's a good starting point. Certainly, if you would like staff to kind of lead an effort to put all of those in kind of one working document, we're happy to help and happy to participate in working on just a uniform set of criteria.
Well, then might I suggest coming back perhaps with a consensus draft at some point regarding that particular part of the rule being changed, the legally enforceable obligation section, maybe in a couple of months, because I tried to find out the date of the publication of the FERC final rule, but I don't think it's been published, or if it has, somebody could correct me. I would like to know the exact effective date, because I know it's 100.
Hey, Judith, this is Adam Alvarez with PNM. It's December 31st, I believe, is when it's going to become effective.
Okay, because it said 120 days, so it was published at the end of August?
Yeah, I'll find it and I'll follow up.
Okay.
It's the first week of September, Judy, when it was published.
Okay, all right. Well, perhaps is 1 month too soon to come up with a consensus draft rule change to the legally enforceable obligation? Don't everybody answer at once.
Judy, this is Jason. I'm not understanding exactly what you're requesting. You're requesting that staff speak to the interested people and come up with something, or are you asking the people to?
Yes, that's what I'm asking. That staff could, and the other interested parties that are interested in this particular rule amendment regarding legally enforceable obligation and establishing criteria for financial and commercial, financial commitment and commercial viability, if they could come up with a potential draft. I mean, maybe it's not possible, but maybe it is.
I think that's a pretty big ask of staff at this point. I mean, with everything else we got going on. I mean, I'll let, John, you can chime in if you want, if you think differently, but I mean, coming up, herding all these cats basically and getting everybody together and pulling together a draft like this in like 30 days seems to me to be a very difficult ask.
Well, I was thinking just pertaining to this one section, the legally enforceable obligation, not the whole rule change. Because I see that section as perhaps being the most controversial given our past history in the PRC. But if anybody disagrees with me, I'll be interested in hearing what other people think might be the most controversial section. Jason?
I'd be speculating, Judy, but I think it will turn out to be the pricing.
Excuse me? I didn't hear you.
I'm speculating. We had an ambulance here. My speculation is that the pricing aspect of this will turn out to be the most controversial, and that
yeah, maybe you're right.
Well, but do the utilities think it's possible for the utilities to all come up with a utility consensus rule that include the co-ops, and then everyone who's not a utility could respond to that?
That sounds like a reasonable idea, given the fact that I understand what Brad is saying for sure. Staff is quite busy, and I would like to get, a NOPR issued fairly soon, since the FERC rules are going to be effective. I don't want, does anyone, PNM, EPE, SPS, could you all draft a consensus rule?
Judy, this is Ron Moss. I suspect we can. I think Nancy may have trouble connecting, so I need to confirm with her, but I believe we probably can agree on some language, or at least we can discuss some language and see if we can come up with something on that. But to be clear, are you just now talking about the objective and reasonable criteria for a legally enforceable obligation, or are you talking about a more comprehensive rule language? I'm kind of echoing Jason's comment there from a moment ago, I think.
Well, obviously, you could do it in steps, if time, it would be, or
I suspect we could get the objective and reasonable criteria language done in 30 days. It may take a little longer on some of the pricing because, as was said earlier, each of the three main utilities is in a different circumstance. SPS is in SPP. PNM is going to be a member of the California ISO balancing market. EPE is not a member of either of those. And so the three investor-owned utilities all have different circumstances, and the co-ops have their own circumstances. So that may take a little longer to work through. But I suspect if we're just talking about the reasonable objective criteria, we can do that within 30 days.
well, that would be very, very good. Thank you, Ron. So I would say that might be the first step, is having the IOUs and the co-ops, if applicable, come up with a consensus rule on the LEO within 30 days. We could reconvene after that, and if everyone is, and discuss it, and if everyone is okay with that, we could move on to the other piece that Jason was talking about, the pricing. How does that sound?
Judy, it's Dan Najjar.
Yeah.
I would, if we're going to do a consensus or attempt to get there from the co-op's perspective, it would be better if it was due in mid-November, because for us to gather all of our co-op members together, we need to have a board meeting, and that next one isn't until the first week of November. So I want to make sure if we're presenting you something, it occurs after our statewide board meets and those co-ops have an opportunity to review it. And then I would also remind the parties on the phone that they should include, to the extent they want to include other co-ops, both Kit Carson Electric and Jemez Mountain are not represented by the statewide, and they need to be included separately in any discussions.
Thank you. Yes, I think maybe having it due the week, sometime the week before Thanksgiving would work. And then the problem is December becomes such a big problem for everyone, but we might be able to schedule another workshop sometime in December before the holidays start. And again, the second workshop, I think, would be for everyone to say that they like the consensus rule and then to move on to the pricing issues. Refresh my memory, have people filed comments on the pricing issue that Jason was referring to? I know Jason did, but.
No, I didn't.
Oh, you
I
didn't?
No, I did not.
Oh, okay, sorry.
But
Nobody.
I know PNM.
Go ahead, sorry.
Go ahead, Jason.
Oh, it appears PNM has, and I think other utilities have.
Okay.
Ron was saying that the pricing will take longer than the financial criteria, which I think so. But Ron, what do you think about working on them in parallel so this thing doesn't drag out until the end of 2021? So try and shoot for an earlier end date for the criteria, but start working on a consensus utility rule that other people could respond to on pricing.
I think we can do that. What I would also say, though, is that from El Paso's perspective, it seemed too difficult to try to capture all of the possible permutations of pricing in a single rule. So what we had proposed is that we just give everyone the option, not the option, actually the obligation, all the utilities and co-ops, the obligation in the rule to come in and do a tariff proceeding and use one of the options that FERC has given us. Now, I know PNM proposed something different, and that's fine. That's something we should work out. But one thing we ought to think about is whether we really even need to try to prescribe all of the different parameters of pricing in a rule, or whether that should be done in individual utility tariff proceedings. I just throw that out for discussion.
This is Stacy Goodwin. PNM did propose some language just that went to the fact that we'll be joining the energy imbalance market in the CAISO. I think Dan Najjar's comments also had a good point for the Co-op Association, and which just mirrors what Ron just said, which is the need for flexibility in the rule. So, I mean, we're happy to have discussions about it. I think maybe there's less need for prescriptive language in the rule on the pricing, and we can simply make sure that the language that exists does allow the necessary flexibility for each utility to come in as they do every year with a tariff.
Well, my initial thought is that in some ways that makes a lot of sense, and in other ways, I wonder if that might lead to every year there being a lot of litigation over it.
So I don't think you would have the litigation every year. I think what you would do is you'd have a tariff proceeding where each of the utilities and co-ops, as necessary, came in, established their method, whether it was an LMP or competitive solicitation or some sort of market index. And then you just live with that until the next time the utility decides to apply for a different method. I don't think this would be an annual litigation. But
so Ron, this is Jason. What happens if the EPE and all the other utilities file their tariff, and then 18 months from now, a renewable developer that's not interested in New Mexico today, or when you file the tariff, gets a project going and decides that they don't think your tariff is compliant with the intent of the FERC regulations? Do they have an opportunity to try and set that tariff aside, or is it too late?
Well, I'm certainly not the arbiter of that, but I don't think there's any reason. I mean, I don't think it would be res judicata as to anyone. You can always come in like you've done and with some of your clients and say, we don't think the rule is compliant. I don't see why you couldn't attack a tariff as well.
I can only say
they'll have a different view on that.
I can only say from the commission's perspective, I would say our goal would be to have a rule that would not, kind of make litigation unnecessary. But I'm not saying that that is actually even achievable, but that would be the goal.
What I would say in follow up to that, to Jason's question, is that your remedy may not be great before the commission, because if the commission approved the tariff, it might say, there's nothing wrong with that. But there's nothing that would stop you from going the route to go to FERC and say this tariff is inappropriate, and then follow that up with a suit in federal district court, which is a path you can go, obviously.
Well, Ron, I liked how I heard your first answer better than the second one. If we're not going to litigate it in this case, a rulemaking where all interested parties hash out what the commission rules should be, and it turns into a real rule, like Judy, I think, was anticipating, some, whether it's guidelines or, standards, real standards, there'll still be some variation, I'm sure, with details, but some real standards, not something completely open-ended. If we don't litigate that now at the commission, a renewable developer should not have to litigate it in district court or at FERC, which is not only a lot more cumbersome, but takes so much time that kills projects just on that. So there's just not fair way to do it. Judy's instinct, I think, is correct, that we need to try and put standards in so they're not relitigated. And the only thing that gets litigated are, the facts of a particular application or particular utility's avoided cost.
Well, we may be talking past each other to some extent, Jason. I would assume that in each of the tariff approval proceedings, we would be litigating what the standards would be for that particular utility. And there would be nothing that would prevent a developer from coming in later and saying, I don't think that complies with PURPA or the FERC regulations. I just don't think it would be particularly effective if it's already been litigated at the commission to go back to the commission and say, we don't think this is compliant, because that's probably been addressed in the time of the litigated tariff proceeding. But that being said, if we want to litigate or we want to work through the standards as part of the rulemaking, I don't think from EPE's perspective that's a real problem. It just seems like it's hard to do from with all the different circumstances that we have in investor-owned utilities, co-ops, and so forth.
I know. I know what you're saying. Sorry, Jason. Ron, but couldn't you say, like, if scenario one, if you're a utility that belongs to an ISO, this is the standard. If you're a utility that doesn't, this is the standard. Couldn't you make different scenarios, and then each utility that was in each particular scenario would know what roadmap they'd have to follow?
Yeah, I don't think there's any reason that we couldn't come up with standards like that.
It'd just be a little bit longer rule, but I think that's a better approach, Ron, just because I think there are entities that will participate in this rulemaking and represent the interest of QFs. It may be something like a Vote Solar or a Sierra Club, or somebody who I'm not their attorney. I don't know. It may be SIA or AWIA or somebody, but I think it's less likely that those entities will litigate a tariff filing by a single utility, and I think it just leaves the questions unresolved. I think we're better off resolving it now.
Okay, I don't think El Paso would have a problem with that, although, again, I've not been able to speak with Nancy about this. But I think the co-ops probably need to weigh in on this some as well, because it's pretty easy for SPS, which is an SPP, and for PNM, which is going to be in the California Balancing Authority, maybe less clear for El Paso. The co-ops may have some different views on that. We just need to hear from them, I suppose.
Judy, it's Dan. I'm turning it over to Kevin. He's now rejoined us, and I have to go to a pre-hearing conference on another commission case. So I think Kevin is on and he can respond.
Okay, thank you, Dan. Kevin, please respond.
I think we could certainly kick this round. Most of the co-ops are going to have one or two stranded costs. It's either going to be what Tri-State's stranded costs, avoided costs, either what Tri-State avoided costs is or Western Farmers. Because that's the basis of the filings I make every year on behalf of our 14 members.
All right, well, I think what I'm hearing is that the utilities and the co-ops could come up with a potentially draft consensus rule regarding legally enforceable obligation for some time prior to Thanksgiving. And then I think we could have another workshop. It would be nice before the other workshop in December to have some proposals regarding avoided costs. And does that sound like a decent plan?
Yeah, I think from our perspective, that sounds like a plan. We will certainly try to, we will come up with some language on the criteria for LEOs. On the other, we will work with the parties to see if we can come up with some language on that.
So, I can ask a commissioner to sign a single signature order setting out dates for the filing of, something regarding LEOs and the filing of something regarding avoided costs, and then scheduling another workshop sometime in December. And John, do you have any comments regarding that?
No, I don't. That sounds okay with me.
And Brad, do you have any comments regarding that?
I think if it's okay with John, it's going to be okay with me.
And anybody else? I have any particular needs or requirements that that haven't been addressed so far?
Amber, this is Judy Parsons. Nancy was having difficulty joining with the audio. She was having some issues, so that's why she's not been able to respond. She's working on that. But as Ron Moss said, I think EPE is fine with that as well.
Okay, and Zoe, could you speak for SPS?
We're fine with that timeline. Thanks, Judy.
And Stacy for P&M?
Yes, that works for us. Thank you.
Okay, and well, with that, I want to thank everyone for attending today. And I was hoping we could do this in an hour, and it seems like it's just about 3 o'clock. So unless someone else.
Before we end this meeting, I just wanted to let everyone know I was able to get the live stream started about 5 minutes into the meeting. So most people who wanted to see the live stream should have been able to connect to it. We had a link up on the website. But we also recorded this, so I think we'll be posting a recording too, just in case anyone wasn't able to watch it if they do want to.
Well, thank you, Isaac, for all your work. I mean, Isaac is a magician when it comes to making things work out, and we're so lucky to have you. That being said, I want to thank everyone for attending, and you know, I truly do believe that we can come to a consensus rule, and that could be a guide for the future and avoid the endless cycle of litigation that the commission has been involved with. But maybe that
We lost.
What? Maybe that's too optimistic, but that's the goal.
Judy, this is Kevin. One more request. Can we send you in some cleanup on the certificate of service?
Yes, that would be helpful. Thank you.
Okay.
And with that, I would like to end this workshop.
Thanks, Judy. Thanks, Isaac.
You're
Thanks,
welcome. All right.
Thanks, Judy.
You're welcome.